Hello students, welcome to Module 6. In this module we will be discussing the effect of discretion on sentencing criminal offenders. By the end of this module, you should be able to identify types of sentencing disparities, articulate the influence of gender on the sentencing process, identify the occurrence of discrimination by criminal justice system actors' abuse of discretion, differentiate between contextual and individual sentencing discrimination, distinguish between disparate sentencing and discriminatory sentencing, explain the role that discretion still plays in the sentencing process, particularly in low-level criminal cases, examine the historical context and development of the jury nullification process, and critically assess the use of discretion in the sentencing process across time and place in the United States criminal justice system. Before going through the PowerPoint, you should have read chapters 4 and 5 in the Spahn book and the Butler article. The first thing we will be discussing are the different types of sentencing disparities. Dr. Spahn has a great table on page 130 that outlines these different types, so I'll briefly review them. First, there are interjurisdictional disparities, which means that judges in different jurisdictions sentence similar offenders differently, with intra-jurisdictional judges in the same jurisdiction sentence similar offenders differently. And lastly, intra-judge is when the one judge is inconsistent with his or her sentencing decisions. There are 3 different perspectives used to explain why women may be treated differently during the sentencing process. They are the chivalry, paternalism, and evil woman hypothesis. The chivalry hypothesis suggests that judges treat women more leniently because they believe they are protecting them and/or their families from the difficulties of incarceration. The paternalism hypothesis suggests that judges treat women more leniently because it lessens their status in the broader society. Lastly, the evil woman hypothesis suggests women are treated more harshly because they violated their gender roles by committing crime. In other words, committing crime isn't a very womanly thing to do. There can also be differences in sentences of men and women because of the differences in the nature of the case. For example, men typically commit more serious crimes and have more extensive prior records. Also, sentencing differences could occur due to judges' perceptions of females and males' dangerousness, blameworthiness, and child care responsibilities. Research typically finds that women are treated more leniently than men on a number of different outcomes. There are many different types of discrimination, including institutionalized, contextual, subtle, and direct. We will go through contextual and individual sentencing discrimination on the next slide, but basically discrimination can occur in many different levels of the criminal justice system. In terms of direct discrimination, some judges consider extra legal factors that are inherently biased toward minority races or different genders. For example, in some jurisdictions, judges are allowed to factor in whether or not the offender has a job into their sentencing decisions. Minority offenders are less likely to be employed and thus more likely to receive a harsher sentence than similarly situated white offenders. This is an example of institutionalized discrimination. An abuse of discretion can occur if there are no grounds for one's decision, which is difficult to ascertain because it isn't always clear what factors are legally irrelevant in a case. Therefore, abuse can occur when judges make decisions about the case based on characteristics of the offender rather than characteristics about the crime. For instance, women can receive less harsh sentences than men. That's one example. Contextual and individual discrimination are the result of discrimination rooted in judicial prejudice or bias toward specific people. Contextual discrimination is limited to certain situations and contexts as opposed to systemic discrimination. Here, discrimination can be confined to certain regions, to different types of crime, etc. One example they give in the book is that African American men convicted of murdering white women are more likely to receive the death penalty than African American men murdering other African American men. Individual discrimination occurs when particular judges give different sentences based on offender characteristics. For For example, one judge might sentence a female offender more leniently than a male committing the same crime. Because it is a discriminatory act made by one judge rather than a pattern of the criminal justice system, this is an individual act of discrimination. A disparity is defined as a difference in treatment or outcome that may not necessarily be the result of bias or prejudice, whereas discrimination is differential treatment based on irrelevant characteristics. With regard to sentencing, as we've been discussing, disparate sentencing occurs when similar offenders are sentenced differently, but it could be the result of jurisdictional differences, for example. Discriminatory sentencing is specifically when legally irrelevant characteristics affect the sentence after all the legally relevant variables are taken into consideration. So offenders are being treated differently because of characteristics about them personally. In a criminal case, a judge has the option to sentence an offender to imprisonment, probation, or both. Low-level criminal cases, or rather misdemeanor cases, have been increasing for the last 40 years, nearly doubling since 1972. Before the 19th century, judges were allowed to impose an unlimited amount of imprisonment in misdemeanor cases. However, they mostly imposed fines. Their discretion in misdemeanor cases was a lot more flexible compared to felony cases. With sentencing reform, the goals of punishment have changed. The bottom line, however, is the idea of proportionality and parsimony. Offenders shouldn't be punished more than necessary, and the punishment should be relative to the crime committed. Most criminal cases are misdemeanors, approximately accounting for 80% of all cases. For misdemeanor cases in most jurisdictions, judges are only guided by statutory minimums. In other words, their discretion is pretty broad. Secondly, there are several obstacles such as unfair bail practices, right to counsel restrictions, and prosecutorial discretion failures that make it difficult to properly exercise discretion in misdemeanor sentencing. Additionally, they often consider the collateral consequences that a conviction for a minor charge might bring, so some people who should be punished might not be either in part of a failure of prosecutors to bring charges or judges failing to hand out a sentence. Most misdemeanor cases do not result in jail time. In some jurisdictions, judges defer to the plea bargain sentence negotiated by the prosecutor and defense attorney. In many jurisdictions, a large percentage of the cases are dismissed, so the judge will never impose a sentence. Although this is not always the case, look up Monroe County or New York if you're interested in learning about a jurisdiction that tries a lot of misdemeanor cases. Jury nullification occurs when a jury disregards evidence presented at trial and acquits a defendant they believe to be guilty because they object to the law that was violated or the application of the law to the defendant. In other words, they vote in conscience rather than by facts or judicial instruction. In the United States, the jury nullification process begins with the common law idea that the function of a jury was to decide justice. If they believe the application of the law would lead to an unjust conviction, they are allowed to acquit. Currently, it is frowned upon for juries to decide a case based in conscience rather than fact, but it is still allowed. If you're interested in learning more about the historical background of the jury nullification process, read about the Bushell case in 1670 and the Zenger-Libel case in 1735. Discretion can be utilized differently across time and place. With regard to place, research has examined how judicial discretion varies across courts and how it is related to broader social and political characteristics. For instance, one study found that offenders sentenced in larger courts are treated more leniently than offenders in smaller courts. Additionally, courts with higher caseload pressure are associated with an increased likelihood of downward departures, while trial rates increase the likelihood of upward departures. These findings suggest that courts are concerned with efficiency, meaning they want to process as many cases as possible. With regard to time, review the sentencing reforms we discussed earlier. This demonstrates how the use of discretion has changed over time. We're now at a place where guidelines are advisory, so judges have more discretion than they have had in previous years.